Respondent. Please be seated.
Mr. Sunday. My Lords, I appear in this matter for the appellant with my learned instructing attorney in this body. For the respondents, my learned friend Mr. Bowen, King's Counsel, the Solicitor General, Ms. Sharma, King's Counsel, the Deputy Solicitor General, Ms. Allen, and Mr. Johnston here. My Lord, what I plan to do is deal with the issues broadly in the order in which they've been listed. I say broadly on the basis that our position has always been that the issues identified as 3 and 4 are effectively linked, so I will deal with them together. I also anticipate that I am probably going to spend less time going to the underlying materials, including the legal materials, than I normally would, just because I'm conscious of the time estimate we need to finish on time. So I'm going to ask the Court's indulgence to take perhaps more notes and take away more homework than it would normally do, but I hope the Court understands why.
Yes.
The first issue, obviously, which in some senses is the one that raises perhaps the greatest issues of principle, is whether the Court of Appeal was correct to conclude that the Grand Court could and should, in fact, conduct a closed material procedure, what I'm going to refer to as a CMP from now on, in this case. And the starting point we would submit in relation to that issue is, as I think the Court will be very familiar with, the fact that a CMP is a significant interference with the rights of the individual under the common law. And I emphasise the common law because I recognise that, as I think we've said in our statement of case, CMPs have been accepted as being compatible with Article 6, and that's in our submission why the leading authorities have tended to focus on the common law. And the clear statements of principle which we submit really are not in dispute in relation to this case are, firstly, Lord Dyson in our RAWI, which is at electronic bundle page 1073, paragraphs 10 and 12, where he identifies the fact that a closed procedure, a CMP, is a departure both from open justice and the principle of natural justice, and that's on the basis that obviously under natural justice a person has the right to know the case against them and challenge it. What we would point out at this stage in passing is, of course, those statements of principle were statements of principle about the rights one enjoys during a trial. And I make that point because when we come to Harrow Lambert's, we do submit the Court of Appeal was right to distinguish between situations where courts are authorised to take account of confidential material that cannot be made public to one of the parties, and the situation where an administrative decision maker is able to take account of that material. And so we submit that it's unsurprising that Lord Dyson focused on fair trial rights. The other statement of principle which sort of demonstrates the significance of the common law position, which is perhaps slightly less well known, is from the same case, and it's Lord Kerr's judgment at paragraph 93, where he talks about what he describes as the central fallacy being in that sort of context he's referring to the arguments in favour of the CMP, the central fallacy being the fact that because a judge sees everything, that it's bound to produce a better result. And he makes the comments rather that assumption is misplaced. And the reason why he says that assumption is misplaced is because for evidence to be of value, it needs to be capable of being challenged and withstanding challenge. And I make that point because it's in our submission of importance when one comes to perhaps the second issue, which is what happens if there isn't a CMP here. There is in our submission a danger in assuming that simply because a judge has access to material, it is better than the alternatives, and in particular the traditional approach to PII, which is obviously to have the trial on the basis of the material that is before the court, with everyone having access to it. One reason why in our submission one has to be careful about assuming a CMP produces better results, and again I reference it, it's fairly well known, it is because of the fact that there are problems with special advocates. Special advocates are not a panacea. And Lord Dyson makes that point at paragraph 36. That was the basis, as I think is well known, for the central conclusion in our railway, which was that, at least in general, and I'll come on to the potential exceptions to this, parliamentary authority, either express or implicit, is required for a CMP. Lord Dyson reaches that conclusion at paragraph 48. He reaches that conclusion and then goes on to comment there's no distinction between judicial review and ordinary civil claims. That's at paragraph 62, a point that was picked up by Lord Clark, who agreed with it, paragraph 168 and 170. Lord Hope made that point at paragraph 74. Lord Brown made that point at paragraph 78 and 86. Lord Kerr at paragraph 88. And we would submit that is the ratio, and there's a clear majority effectively for that. And again, I'm not sure that's in dispute. Now, one point that we would make about that is that, of course, what happened in England and Wales following our railway, despite some concerns expressed by Lord Brown at paragraph 78 as to whether there was a willingness to legislate, of course, in England and Wales, and in the UK as a whole, the Justice and Security Act was enacted quickly and represented a judgment, right or wrong, as to how closed procedures should be conducted and when closed procedures should be conducted. And I make that point because it demonstrates how one shouldn't assume in our submission that legislatures are, or parliaments are sort of unable to grapple with this or unwilling to grapple with these sorts of issues. In Cayman, this litigation has been pending for 5 years, as I'm sure the court is aware. It is relatively high profile, but no legislation has been enacted. Now, in our submission, that's an indication, in one sense, that the Parliament, rather, has, for whatever reason, decided not to interfere with whatever the common law position is. And that's despite the point that, as my learned friend points out at paragraph 50, I think it is, of his statement of case, which is page 857, Cayman has, in the context essentially of a body which is, as I understand it, similar to the parole board, the conditional release board, enacted something that is similar to a closed procedure. Now, obviously, our RAWI was followed by at least 2 cases of significance that the parties engaged with and focused on, Bank Mellat and Haralambous. I'm going to come to Haralambous separately when dealing with my learned friend's arguments. Bank Mellat, though, I would just note in passing, in our submission, is quite clearly an example of parliamentary authority being found for the closed procedure. Bank Mellat is electronic bundle tab 7 of the authorities, page 1157.
Mr. Souther, you don't need to mention tab numbers because we don't have them. So just the electronic bundle number.
I'm quite happy to do that. Sorry, the reason I was doing it is I think the list should be hyperlinked. The index to the authorities, I think, is hyperlinked, as I understood it. I have to say I'm a little bit of a dinosaur, so that when I'm arguing cases as opposed to when I'm sitting, I do tend to use hard copy material. But I think you'll find there's so I don't know if it helps for that reason to continue to give tab numbers, but I don't.
The page number was again?
Sorry, 1157 is where the relevant passage starts.
Thank you.
And what in our submission happened in Bank Mellat or the approach rather than the judgment in Bank Mellat that was reached essentially makes this clear, is that in Bank Mellat, the court started by noting at paragraph 30 the appeal rights that were established by the Constitutional Reform Act, and then went on to conclude at paragraphs 55 and 56 that the terms of Section 40 of the Constitutional Reform Act enabled the Supreme Court to hold a CMP, and they enabled the Supreme Court to hold a CMP because, essentially, the intention of Parliament was that any judgment of the Court of Appeal needed to be, in principle, capable of being challenged. So, Bank Mellat, deal with at this stage, we would park on the basis it is simply an example, in one sense, of what we say is the key principle from Al-Rawi, which is you need statutory authority. Returning to Al-Rawi, one reason in our submission why statutory authority, so I will come to Haralambus, but I want to deal with it in slightly different order. One reason why we submit that decisions as to CMPs should in general be left to Parliament is because there are significant decisions to be made. It does represent, obviously, a departure from the common law, but judgments then need to be made about when, for example, a CMP can be ordered. And that is something that in our submission was emphasised by Lord Dyson really paragraphs 38 onwards of his judgment, which is going to electronic page, it is electronic page 1080. And this may be the first point which is worth looking at, material. One goes to 1080. Lord Dyson started at paragraph 38 by looking at the arguments presented by the Respondent Security Services, in that case by Mr. Jonathan Crowe, Queen's Counsel then was, and addressed those, and in particular highlighted the uncertainty in the test that was being proposed. One sees that at paragraph 39. That's something I'll come to. In our submission, it is striking in this case that there are several tests essentially floating around, and that demonstrates the difficult choices that courts, in some senses, have faced if they're thinking of establishing a CMP, and that's why, in many respects, things are best left to the legislature. But then at paragraph 40, Lord Dyson deals with the judgment of Lord Clark, and Lord Clark was in the minority and indicated that essentially it was possible to hold a CMP after PII if the parties sought one, potentially. And at paragraph 41, Lord Dyson disagreed with that, and in his reasoning regarding that judgment, and indeed the judgment of Lord Mance, which was endorsed by Baroness Hale, what he does, in my submission, is identify a number of real difficulties, essentially, with courts establishing CMPs. The first point, which links back in one sense to the points I already made about the importance of common law rights in this context, is that a CMP is, to use his language, the very antithesis of a PII procedure. And the reason for that, and this is the fundamental reason why we would submit that Lord Kerr was correct, essentially, to draw attention to the risks of a PII, of a CMP, is because PII ultimately results in a process where all the parties have access to the material, everyone's arguing from the same on the same playing field, and the court is making a judgment based on that. The CMP, obviously, is a situation where one party has an advantage. Para 42 is then a sort of linked point, essentially, which is that if Lord Clark was right and parties could opt to have a CMP, one of the problems with that is that one party would be at an advantage, because one party would be in a position to know whether a CMP helps them. And of course, we're in that situation here. The respondents are in a position where they know what the material is. They are presumably in a position to judge whether it assists them or not in advocating for a CMP. We have no way of knowing whether that material assists us. Para 43 is probably more important. It's something I'm going to come back to when I look at Macmillan and Friends submissions, which is the difficulty, essentially, faced by a court deciding when to have a CMP. And that's something that a number of judges picked up on. It's also, essentially, the point made at paragraph 39. What inevitably is involved in a court concluding that it can order a CMP is judgments being made about the test to be applied when determining whether to order a CMP. And that produces argument. It results in satellite litigation, according to Lord Dyson, and we would submit that's right. But it also involves difficult judgments of policy. Next point Lord Dyson picks up is the thin end of the wedge, and obviously we would argue that's potentially an issue.
It occurs to me, I can't recollect if Lord Dyson makes the point anywhere, but in addition to the departure from ordinary principles of natural justice and fair procedure, it's also remarkable, CMP, in that it is a non-consensual procedure under which a party is prevented from having any communication or giving instructions to his legal representatives.
Well, my Lord, I don't think he identifies it in this passage looking at disadvantages, but in the passage I mentioned before about where he looks at how special advocates are not panacea, he does make that point, my Lord.
Yeah.
I didn't take you to it because I think it's fairly well established, but he highlights a significant amount of material that draws attention to the problems faced by special advocates.
Yes, I'm not meaning just practical problems, I'm meaning the principle of being represented in court by a lawyer whom you are not entitled to give instructions to or even to have any communications with.
Well, my Lord, I think that material does make, as I say, makes that point. It's not just the practical difficulties. I think from memory, it makes the principal point. And of course, my Lord, in practice also, my Lord used the words a lawyer instructed. Of course, that's often how special advocates are viewed, but as a matter of technical law, they're not instructed by the individual, they're instructed by the state. And that can cause problems in terms of people's confidence in special advocates. They're instructed by the state to act in the interests of the individual, and they have an opportunity to take instructions, but they are not, as a matter of practice, as a matter of theory at least, they're not instructed by the individual. So that's essentially the disadvantages, and I'm going to come. Oh, sorry, and I think I didn't take you to paragraph 46, just in passing. What Lord Dyson points out there is that the test, essentially, that Lord Mance and Baroness Hale would have identified, or did identify in their judgments, was different, essentially, to Lord Clark. And that, he points out, is an example of how difficult it can be for a court to decide when a CMP should be established. And say Lord Hope makes similar points at paragraph 73, Lord Brown makes similar points at paragraph 82. Now, one problem that we would say is not expressly identified in those judgments, but we submit is actually also a very real problem, is that the European Court of Human Rights, in its judgments essentially approving of closed material procedure, and the Grand Chamber judgment that's probably most on point is Regner in the Czech Republic at page 1641, and it's paragraphs 146 to 148, have made it clear that although in principle a closed procedure is not a breach of the Convention, one needs to have counterbalancing procedures in place, and that's the language used. It's para 148, it's counterbalance, and then para 149, it's there needs to be adequate safeguards. And that's, in our submission, a further reason why it's important, essentially, that this is a decision taken by the legislature, because if one thinks about the sorts of judgments that need to be made about safeguards, my Lord's referred to special advocates. Who should be appointed as special advocates? There are rules in the UK as to who is appointed as a special advocate. In Cayman, because there is no statutory scheme, there is, as far as we're aware, no scheme for appointment. And I think you're probably aware that at first instance in this case, a special advocate had to be appointed on a one-off basis, essentially, by the English Attorney General using the English list of counsel, and that's what happened. What systems are in play for communication between special advocates and open advocates? My Lords may have picked up from our statement of case, there's been a dispute in this case about whether or not a communication from the special advocate should have been released, essentially, should have been made public, should have in particular been made available to the respondent. Now, in England and Wales, you have a system whereby the sensitivity of material is checked, as we understand it, without that going to the litigating lawyers acting for the state. There isn't such a system here. Is that necessary? How do you establish that system? Do you require a system for additional disclosure? We make the point in our statement of case at paragraph 13 that if one looks at the procedure adopted by the Special Immigration Appeals Commission, what it does is it departs from normal immigration procedure by balancing to some extent the unfairness of a closed procedure with an enhanced duty being imposed on the state to provide disclosure to the court. So that's a balancing safeguard. Do you impose an additional duty of candour in those circumstances? Because obviously in an open procedure, if someone's unhappy with the duty of candour, they can go back and say, look, there's an issue here. So do you impose an enhanced duty of candour? I'm not suggesting answers to any of those problems. What I'm suggesting is that what that demonstrates is that as soon as you establish a closed procedure, you have difficult judgments to make. And they are best made, in our submission, through legislation, essentially. That's what happens in England. I'm going to come in a moment, when I look at the learned friend's arguments, to the test he argues for. I'll make submissions about the difficulties in relation to that. But before I do that, can I sort of then move on to my learned friend's arguments and take it step by step? The learned friend starts by arguing essentially that there is an inherent jurisdiction. Our primary point, and I may come back to this, is that in one sense, whether there is an inherent jurisdiction that should never be exercised, or whether there isn't an inherent jurisdiction, it's outside the scope of inherent jurisdiction, may be an interesting academic debate, but it doesn't really matter, because the key point, and this is consistent with Lord Dyson's judgment from Al-Rawi, is whether or not the jurisdiction exists, it shouldn't be exercised without parliamentary authority. Having said that, and I want to, because we do submit that there is perhaps a slight misunderstanding about our position, I want to make clear our position. We have said in our statement of case, and I'm not resiling from this, that there are circumstances where courts have apparently concluded that there are inherent powers to order a closed material procedure.
At common law.
At common law. However, what we've gone on to say is certainly in relation to the one example that everyone agrees of a common law, well, the one example of the CMP that has been developed, one can explain that on the basis of statutory authority. I should say the one example of a CMP at trial, because there is the point made that in some competition cases, well, not competition cases, some commercial cases, CMPs are used as part of sort of pre-trial procedure and without apparent issue. But the example I'm talking about is family proceedings. And I'm sure the court's well aware, Lord Dyson, paragraph 6, put this in context and understand what I'm talking about. Lord Dyson, at paragraph 63, page 1085, and it may be worth going to it, considers, let's say 1085, paragraph 63, considers the circumstances in which CMPs have become common practice. In paragraph 63, he identifies family, some certain, well, not family proceedings, some certain types of child care proceedings as being an example. And importantly, and I just ask you to note this, and I'll come on to this in a moment, he refers to an obvious example, and this is the first example he identifies of it, so, chronologically, first example. He identifies a case called In Re K, and a judgment of Lord Devlin as an example of that. He then goes on to look at, in paragraph 64, confidentiality rings in commercial proceedings, and in particular, but notes in relation to that he was not aware of a case where that had been approved for trial. So he's identifying that as pre-trial basis. So you have these two examples, say one, the childcare one, which I'll come on to, and then a pre-trial process. And we would submit pre-trial may be different for obvious reasons. It's not for finding determining the merit. He then sort of indicates that there's no issue with those, partly because of the fact they're well established and not controversial. He then goes on to look at the Competition Appeal Tribunal, which he deals with on the basis that it's inquisitorial. Now, the point I would make is what you end up with out of that is one process where there appears to be the possibility of a trial without full disclosure, or without with one party being denied access to material. That is the childcare case. Now, that is based initially, or the first case, as I say, is cited as K.
Sorry, I didn't catch.
Sorry, the first case cited is K.
Yes.
And I'm just about to take you to K. I hadn't got there. K is an electronic page 2643, not 12643, 2643. And that there you see the judgment of Lord Devlin.
I'm so sorry. Can you give me that page number again?
Yes, sorry, I'm mispronouncing. I misspoke rather. It's 2643.
Thank you.
And what Lord Devlin did, essentially, or what the key reason in our submission in his judgment, is at the bottom of 26. Sorry, actually, the critical passage is 2643. I've taken you to, because at the bottom of 2643, you see that the issue was a confidential report that was withheld from a mother. But at 2646, you see his reasoning at the bottom of the page again, just in the last paragraph, where he endorses the judgment of the trial judge. And the trial judge, just below letter B, makes the point that Section 1 of the Guardianship of Infants Act, 1925,
This is internal numbering 239.
internal number, yes, it starts at 239. The trial judge's quotation, though, is at 240 by letter C, just between B and C. And you see there that he cites the Guardianship of the Infants Act, which established the principle that the welfare of the child, of the infant, was first in paramount consideration. And that's what the trial judge then applies just below letter D to, because he indicates that if the paramount purpose is the welfare of the infant, the procedure and rules of evidence should serve and certainly not thwart that process. So ultimately what K is about, we would submit, even though at times it's referred to as an inherent jurisdiction case, is about the terms of legislation concerned essentially with child welfare. And so it's effectively, again, consistent with the al-Rawi principle. It's basing what's effectively a closed procedure, CMP, on statutory authority, and in particular the statutory authority that requires the welfare of the child to be given paramount consideration.
I mean, he's making it very. I think he's making it pretty clear, the judge, that this is not talking about the inherent jurisdiction of the High Court.
No.
Between A and B, he's telling us that, correctly that the jurisdiction in question is an ancient jurisdiction deriving from the prerogative of the Crown as parens patriae. And then he takes us to its the modern statutory provision, and the point he derives from that is that this isn't a lease inter partes, and therefore it's not, as he puts it, it's not based on the rights of parents.
Yes. Well, that's not exactly our point, because the only point we're making, and as I say, this may not matter in one sense, but for the reasons I already identified, but the point we're making is, although this is sometimes, and we accept this is sometimes used as an example of inherent powers of the court, ultimately we don't accept that it is an example of inherent powers of the court. We would submit, ultimately, it has a statutory basis. See Lord Devlin's judgment, and in particular his endorsement of the trial judge.
Yeah, and even if that weren't correct, even if it were regarded as a common law, even if it were thought to be a common law power, it would be based on the parens patriae jurisdiction.
Yes. But as I say, and I don't want to spend too much time on this because, in one sense, it's a very interesting academic debate. It doesn't really help the court to resolve the issues. Whether actually our Rawi turns on there being no inherent jurisdiction, or whether it actually turns on there being an inherent jurisdiction which should never be exercised. And in fact, if one looks at Lord Dyson's judgment, paragraphs 21 and 22 again, which is page 1075, he makes the point that although inherent jurisdiction is believed to be broad, it has limits, and there are circumstances where you shouldn't exercise it.
Before we leave it, I mean, we were looking at what was said by the puny judge.
Yes.
Lord Devlin, at the foot of the page, at the end of the quotation from the judge, he says, this is the essence of the matter. Then he goes on to say, just before the foot of the page, wherever judge sits purely as an arbiter and relies on the parties for his information, the parties have a correlative right that he should act only on information which they have had the opportunity of testing. So that's the fundamental common law rule of natural justice.
Yes.
Where the judge is not sitting purely or even primarily as an arbiter, but is charged with the paramount duty of protecting the interests of one outside the conflict, a rule that is designed for just arbitrament cannot in all circumstances prevail. So it's a very clear distinction that Lord Devlin is also drawing between this particular jurisdiction and the ordinary jurisdiction of the courts.
Absolutely, Lord. And of course, those remarks about the role, about limitations of, or the difference rather, between when the courts act as an arbiter between parties, may, to some extent, link back to the point that was made about the Competition Appeal Tribunal, because the Competition Appeal Tribunal is not sitting as a simply as to determine arguments of essentially the two parties.
You do risk, you risk, as it were, making the statutory authority exception too wide, don't you? If you don't ask yourself the question, does the statute authorise this procedure? And the Guardianship of Minors Act, 1925, simply said that the interests of the children should be paramount, which, if you like, was the substance for the observations of Lord Devlin, which my Lord has just been referring to. But nowhere in that Act do you find the authorisation for a special form of procedure. But the form of procedure adopted flowed from the nature of the court's task.
Well, the contrary argument, and I'm just conscious of the point I made, which one can get in one sense too wrapped up in an academic point, but and I recognise I started this, so I'm not. but I would accept, because it's quite clear in my submission on authority, that the principle of legality recognises that you can interfere with fundamental rights either because you have express words or because it's necessary implication. And so that's why, to some extent, we would argue that the approach of the trial judge, which was to look at what the objective of litigation was, referring to the relevant provision of the relevant statute, can be read, and this is all we're saying in one sense, as identifying a necessary implication of that duty to self-get. So it's still, in one sense, consistent with the principle of legality, which is what we submit underlines our role. But I have to accept that the principle of legality isn't restricted simply to express words. It is possible to imply an interference with fundamental rights based on necessary implication. But that's a high threshold, I would say.
Well, I think you're probably giving away too much here.
Sorry.
And this isn't academic. I mean, this goes to the root of the issue. Even speaking about the court's task may be slightly too loose. Lord Devlin is focusing on the nature of the jurisdiction being exercised. Now, you could say, for example, in a case like Duncan and Camel Laird, where you have the widow of the submariner drowned in the Thetis in its sea trials during the Second World War. And she brings an action for damages based on negligence against the Admiralty, against the shipbuilder, and wants to recover the plans of the submarine in wartime. And this is a new type of submarine. And she obviously can't recover those, and that's what the court decides. Now, one might have said, well, the court's task in that case was to determine whether there had been negligence on the part of the shipbuilder, and if so, to quantify the damages that had been suffered in consequence. But the jurisdiction being exercised was what Lord Devlin and the judge describe, well, what Lord Devlin calls sitting as an arbiter, determining a dispute inter partes, and so the judge can only act on information which the parties have had the opportunity of testing, as he puts it. Yeah. And so if Mrs. Duncan can't recover the plans of the submarine, then they can't form part of the material before the court. Whereas if the court's exercising a jurisdiction, for example, to determine whether Mrs. Duncan's children should be taken into care, that's an utterly different jurisdiction, where the judge isn't determining a dispute inter partes, but is required At common law, it's not only, the statute is really just reflecting the nature of a parent's patriae jurisdiction at common law, where the judge is required, as his paramount function, to protect the interests of the child.
Well, I agree, obviously, that there is a fundamental difference. Where I am slightly cautious about going, and this is one sense why I pointed to the statutory origin of K, is ultimately, if you were, and it's difficult in one sense to roll the clock back, but if you were to be simply dependent on common law jurisdiction to for example, have a role to have jurisdiction to determine an issue in relation to childcare, because the right to a fair trial is so much a core part of the common law, I'm not sure it would be open to a court to establish a CMP. I'm not sure that the correct approach of applying our role wouldn't be to say, well, look, there is a problem here. We have to apply these common law principles. They are so well established. Ultimately, if the legislature wants to, or the Parliament wants to address these problems, that's a matter for Parliament. And that's, in one sense, what happened in our role. And of course, Parliament then acted in response to it. And that's, in one sense, why I'm focusing on. The reason why I say, in one sense, that also is academic is because, as I say, Lord Dyson makes the point that if you were in those circumstances to conclude that there is no common law jurisdiction, that might be on the basis that that's outside the inherent powers. It might be on the basis it simply isn't appropriate for the court to exercise those inherent powers. Whichever route that is, you end up in the same position, basically. But I certainly would submit that the common law rights in issue are so fundamental that for a court now to develop a further common law right to a closed procedure or common law closed procedure is a very radical thing to do, and ultimately what our role is about is it's best left to the legislature.
Another point that might perhaps be made in relation to this family case is that it isn't actually an example of closed material procedure as we understand it. No. Rather, the court, in proceedings of this kind, appoints a guardian ad litem to the child, who's the ward. So there's a guardian ad litem who then prepares a report for the court, and all that's an issue is whether the judge is entitled to take account of part of a report which is not made available to the parents.
Yes.
And the same arises very broadly in relation to trusts, and in particular charitable trusts, so the Beddoe jurisdiction, where the court acts to give trustees directions. It may call for submissions from beneficiaries, but routinely doesn't give them all the materials that the trustee has put before the court. Now, that's not a closed material procedure, but it is another example of what isn't a straightforward inter partes piece of litigation, because the court has got a supervisory jurisdiction, and of course it has a statutory one in relation to insolvency. But do we need to go down any of those roads if, as I imagine you submit, judicial review proceedings are adversarial procedures between the parties?
Yes. I mean, this is why I'm sort of slightly concerned about I drew myself, in one sense, into this area, partly because I wanted to be absolutely clear about what our position was, because of what it was said we'd conceded, and I don't think we did concede it, and certainly we're not conceding it. But as I said, I'm equally conscious of the fact that fundamentally our point is, whether this is inherent jurisdiction or not, it is quite clear that in adversarial proceedings, and that may be the best way of putting it, whatever powers may exist shouldn't be exercised by the court because they are such a fundamental intrusion into fair trial rights. Can I then take you to what in one sense is the key stepping stone point, whether or not there is inherent jurisdiction that my learned friend relies upon, which is the Haralambous judgment. Haralambous, in our submission, is a narrow authority that ultimately turned on the statutory scheme. And Haralambous, I think the relevant passage starts at page 1359 of the authorities of the electronic bundle. And was, I'm just sure probably you are aware, it was a judicial review of proceedings essentially warrant, in relation to a warrant. And the issue was whether the judicial review, in circumstances where it was outside the 2013 legislation, could involve a closed procedure. Now, the starting point in our submission is Lord Max's conclusion, which he reached before dealing with whether or not there's a closed procedure, at the end of paragraph 44, which is that the Magistrates' Court and Crown Court could take account of closed material, in other words, material withheld from the person affected. Now, in one sense, one might say this is, again, not traditional inter-parties litigation, partly because, although my learned friend is correct to say that there was no express provision for a closed procedure in the lower courts, what there was a provision which was section 15 of the Police and Criminal Evidence Act, which is at paragraph 3 of the judgment, subsection 3, a procedure, a statutory provision that which actually didn't just authorise an ex parte procedure, it required an ex parte procedure. And so, although, as I say, it wasn't as formally as a closed procedure, it was very close to it, and in particular made it clear that it was Parliament's intent that normal rights enjoyed by a party to litigation would be denied.
I'm sorry, I'm looking at section 15.3 in paragraph 3, and I don't, I'm not sure I'm seeing what you're telling me. I should find that.
Sorry, subsection 3, which is by letter F, an application for such a warrant shall be made ex parte.
Yeah. Okay.
I mean, that was the key passage in Haralambous, which effectively then reaches the conclusion that there was a power to hold a closed procedure. It's paragraph 59, where Lord Mance looks essentially at the justification. And he starts in our submission by indicating that judicial review can and must accommodate a closed material procedure where that is the procedure which Parliament has authorised in the lower court or tribunal whose decision is under review. Unsurprisingly, I emphasise the words court or tribunal. He makes some remarks about al-Rawi and whether or not this was within contemplation of al-Rawi, and to some extent indicates what might have happened had it been within the contemplation of the court in al-Rawi. But then, in our submission, the key reason, essentially, is the sentence that starts, be that as it may, which then goes on specifically to identify two matters: the scheme authorised by Parliament for use in the Magistrates and Crown Court, and Parliament's understanding as to the basis upon which judicial review would operate. Now, that scheme in our submission is very different from the scheme in question in this case. The scheme authorised by Parliament, as I've already indicated, it expressly provided for an ex parte procedure. So one can see that a departure from normal common law rights had been authorised by Parliament. That's very different to the situation we are considering, which is obviously a situation where the decision maker is an administrative decision maker and those fair trial rights don't apply. Now, it is true that Lord Matts then goes on to refer to judicial review and the statutory provisions that apply in judicial review in England and Wales. It's important to note, however, that if one goes back to paragraph 56 and letter F, he refers first to the Senior Courts Act and the provisions of section 31, which effectively define an application for judicial review, but specifically draws attention to subsections 5 and 5A. And 5A is the power that allows a court or tribunal to substitute its views, essentially, or reach its own conclusions, substitute its own decision. And so one sees the statutory framework he's talking about in relation to judicial review also is focused on challenges essentially to courts. So you had this situation in our submission where you had a court authorised to consider ex parte material on an ex parte basis, departure from normal trials. You then had the particular powers that were given to judicial review courts in relation to courts, which allowed them to really take the decision. And that is in our submission why Lord Matts referred to this as being a very special situation. Now, it's true, Lord Matts did also refer to it being unsatisfactory if the court were to determine the issue on a different basis to the court below. One sees that at para 57. But that's clearly not, we would submit, at the heart of his reasoning, because if it was, it would essentially imply that one could always have a CMP whenever one had PII in judicial review, because you're always going to have that problem. So, in our submission, Haralambus is authority essentially for the authority that one can hold the CMP in a very specific situation where that was the inevitable consequence essentially of the part of the statutory scheme that governed both the judicial review, but also, more importantly, the lower court's decision-making. Now, maybe in passing, I should just deal very quickly with the point that my learned friend makes, which is to say, well, if we're right, and there is no CMP in this case, and if we're right that the judicial review just takes place on traditional grounds, adopting the traditional approach that would apply whenever PII is applied, you then have a problem, because if we succeed in our judicial review, the matter goes back to the decision maker, and the decision maker will take a decision on greater material, the material that's subject to PII. Our answer to that, well, there's several answers to that in one sense, which is, firstly, in our submission, when a decision maker takes a decision, it must, if they are going to respect effectively the rule of law, take account of the fact that they potentially need to justify that decision to a court. The authority I won't take you to that we cite in relation to that is a Court of Appeal authority considering control orders. It's BX, which is electronic page 2218. It's paragraph 55. And in our submission, it cannot be right, not least because of the need to respect judgments of the court, for a decision maker to say, I know if I take a decision relying on this material, I will not be unable to justify the decision because of my disclosure obligations, which I can't comply with. In our submission, that would be, to use the language of the Court of Appeal, an arbitrary use of power. But if that causes a problem, that really is a fundamental problem for the executive. Of course, the solution, the real fundamental solution, is to legislate. I mean, if the consequence of the application of common law powers is a problem for the executive, while the executive can potentially seek the approval of Parliament for fresh legislation. Now, what is striking in our submission about my learned friend's reliance on Harrow-Landers, and it does demonstrate the difficulties that we would submit for the court, is that although, as I say, we would submit the key reasoning in Harrow-Landers is paragraph 59, although the Court of Appeal adopted a different approach, and essentially the Court of Appeal, in its judgment, I won't take you to it, it's electronic bundle 48, it's paragraphs 146 and 147, concluded essentially that there should be a CMP because it would be unsatisfactory if there wasn't one, all the options were unsatisfactory, and there was this express right to bring a challenge under the Bill of Rights. What my learned friend in my submission advocates for is a different test, and it's a test that is set out in his statement of case, essentially, at paragraph 23. It may be worth turning to that. It's page 847 of the electronic bundle. In the core authorities, if anyone's using those, it is tab 5. Let's say paragraph 23. Now that, in our submission, isn't the approach of the Court of Appeal, as I've already indicated, and the reason for that may be that the approach of the Court of Appeal would essentially imply one would always need a closed procedure if ever PII is claimed in relation to a case relying on the Bill of Rights. What in our submission these criteria are, for obvious tactical reasons, we understand why this is the case. They're an attempt essentially to narrow the circumstances in which a judicial review, in which a CMP can be ordered, while at the same time ensuring that the principle isn't so narrow that this case falls outside it. But it does raise very difficult questions. So, for example, the learned friend doesn't argue that a CMP should be required whenever a case becomes untriable. Now, obviously, we don't accept this case is untriable, and I'll need to come on to that. But in one sense, if there is this power to order a CMP outside of any express statutory provision, why should certain cases become untriable and not others? My learned friend also, at paragraph 24, argues there's no need for national security to be in question. But why, if that's the case rather, that would, in some senses, because there's no obvious reason why the common law should be any different in Cayman to the United Kingdom, that we would submit have the potential to undermine the UK Parliament's decision to limit CMPs to national security cases. And one sees also the potential for significant argument. My learned friend starts in paragraph 23 by indicating that the starting point is there are special reasons in the interest of justice. Now, that's a very similar test to the test proposed by Mr. Crowe in the Al-Rawi case, and the sort of test that was criticised for being likely to give rise to significant litigation. It also indicates, see paragraph 23.4, the test is also meant to consider whether the information withheld is so material to the decision that the case cannot be determined fairly without the CNP. How does one determine whether the information is so material? One can see argument about that. And so the test in our submission is, we would submit, open to criticism on the basis that it is lacking in principle and will potentially give rise to significant litigation. And as I say, it doesn't, in our submission, reflect the approach in Harambas.
Mr. Sully, why was it necessary to have disclosure of the underlying material in this case?
Why is it necessary to have disclosure of the underlying material? In our submission, it is necessary to have disclosure because, in part, one of the potential grounds for judicial review is whether there is actually, it's the Edwards and Bairstow technical question, is there actually material that justifies the conclusions reached?
But in the normal course of a judicial review, a decision maker gives reasons for the decision. The court then examines the reasons which are given,
Well,
as to their legality. It's not normal to obtain underlying material to see if there is a basis for the views expressed.
Well, 2 points I'd make in response to that. Firstly, of course, you have the Tweed principle, which is that if a decision maker is going to refer to material, then it normally should be exhibited, in part because that allows everyone, including a claimant for judicial review or an applicant for judicial review, to identify whether there is material that justifies the conclusions reached. But as I say, secondly, the duty of candour, even without Tweed, would suggest that the material that is potentially relevant would require to be disclosed. And that is so that ultimately proportionality can be assessed, taking account of whether or not there is sufficient material to justify it. Now, can I just give an example of where that may be relevant, a real example in this case? You will have seen that one of the arguments that has been run by the applicant is that Cayman has recognised since at least 2009, if I remember the year, that it had a problem housing high security prisoners. That's when the first prison got moved from Cayman to the United Kingdom. Strasbourg Authority says pretty clearly that resources are no answer to complaints that you are located an excessively long distance from your family. The state is obliged effectively to make facilities. So there is an argument, the Court of Appeal recognised there was an argument that Cayman should have built a prison to cope with high security prisoners so that this problem doesn't arise. The Court of Appeal's concern essentially was that there was some reference to the potential difficulties accommodating the applicant, the appellant rather, if a high security prison was built. But it was something to the side, and there was also reference in the materials to the applicant, the appellant rather, potentially being brought back to Cayman if security arrangements at the prison were improved. Now, that is the sort of example where in our submission the Court of Appeal was correct to say, if you're going to assess the proportionality of the failure to build a prison and whether or not that's impacted in, well, perhaps more accurately, if you're going to assess the proportionality of the decision to remove in light of that, that is a situation in our submission where you do need to understand something about the risks posed by by the prisoners.
Do you need the underlying documents in order to be able to form a view as to the risks posed?
Well, you need, at the very least, you need greater detail of what the risks are, so that you can understand whether it is a real fear that their risks simply cannot be managed on Cayman, despite.
Well, that might result in a reasons challenge.
Well, my lord, it might. I mean, and obviously, in one sense, we would accept what we would ultimately accept, although we dealt with other possibilities, is that ultimately the way forward in relation to this is for the court to conclude there's no CMP, to remit this matter to the Grand Court, and for the Grand Court to try the matter as best it can on the material it's got, and see what conclusions it would reach. And we would accept that's the sensible way forward, effectively.
Right. For my part, I'm puzzled as to why it was thought necessary to obtain these underlying documents in the first place.
Well, my lord, it goes to one sense, the lack of detail in the material that's been disclosed. It's not being suggested, I think, by the respondent that this was not material that was disclosable under normal judicial review principles.
Well, we don't normally have a discovery process. Well, it's not normally necessary to have a discovery process in judicial review.
But Lord, this wasn't dealt with. This wasn't dealt with as a discovery process. What it was dealt with, I'm pretty sure, I can't remember. I might need to check the procedural history, but my memory is that this was dealt with as an application by PII of the PII, based on the fact that obviously there was a duty of candour.
Yeah, and I mean, as is usual in PII situations, you've been given the gist rather than the ipsissima verba.
Yes, but my point is, my lord, it's not. This isn't a situation as from memory, and I haven't gone back through that part of the history of this case, and obviously it has a tangled history. But this isn't a case of the applicant making a sort of specific, which is obviously rare in judicial review. It's a situation where the respondents, acting as responsible public authorities, recognised they had certain duties of disclosure, recognised they couldn't comply with those duties because of PII, and sought PII. So we are in a situation where whatever this material is, and obviously I'm not in a particularly good position to know what this material is and how relevant it is, but we are in a situation where the material was identified essentially as potentially being disclosable, but PII was sought.
Thank you.
While it's in my mind, can I just say that before you sit down, it would be helpful for us to know, in relation to the question of relief, if we were with you on the CMP issue,
Yeah.
whether it's actually necessary to remit to the Grand Court, or whether we can take the decision ourselves.
I think in our second case, we've acknowledged it would in principle be possible for the court to take a decision itself. Mm-hmm. Having said that, and we understand why the court was keen to fit this matter in today, and given the delay in this matter, we're very grateful for that. Yeah. I think one practical issue will be simply having enough time to address the court in relation to the material. And I think it would be very difficult in the time available for us to, certainly for the applicant, to fully advance the arguments we would advance as to why this, ultimately the claim should be allowed. And for that reason, as much as any other reason, it might well make sense for the matter to be remitted to the Grand Court with whatever assistance can be provided as to the approach should be adopted.
I mean, you do address this in your written case.
Yes, we do. But again, partly because of patronage, partly because we were conscious of the fact that we have to get to that point first. It was addressed in a relatively skeletal way.
Well, yes, and you refer us to relevant authorities
Yeah.
and so forth. It's really pages 834 to 836, I think, in the electronic bundle.
Yes. 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 I mean, there is also one other factor that may be relevant to that issue of relief, which of course is that I don't want to spend any real time on it, but unfortunately, as I suspect the court's aware, the Grand Court judgment was not terribly satisfactory, and I don't want to say much more about it than that. And of course, one issue is that there is something to be said, particularly in cases of proportionality, for there having been a local input, and effectively the Grand Court has never really inputted into this case because of the unfortunate way in which the judgment was delivered. But I equally recognise ultimately, I don't think there's anything in principle that would stop this court potentially determining the issue. The Lord, conscious of the time, and I need to speed up to some extent, my learned friend identifies a number of statutory provisions which he says support his argument that there's a closed procedure. I am not, I think, given the time, going to spend any real time. If I need to, I can deal with it in response. All I would say about them is that they are, we would submit, not express or provisions that require a CMP. They are also not provisions which give rise to a necessary implication that there is a power to order a CMP. And in those circumstances, in one sense, it's very difficult to see what their relevance is. They are provisions essentially that well, there are two categories of provision really. One is provisions which define who should take the decision and what they should consider. All they do is recognise that there will be an administrative decision-making process initially, and unsurprisingly, relevant material can be considered, including sensitive material. That's no different to many administrative decision-making processes. There are then the provisions of the Grand Court Act. Section 11 determines jurisdiction. In our submission, this isn't about jurisdiction. Section 18 deals with the situation where there's no provisional practice. The difficulty with that is that, of course, the availability of a CMP in England and Wales is generally regarded as, in this sort of context anyway, as depending on statute. It would be somewhat surprising if the English or the UK Parliament, by enacting the Justice and Security Act, had enacted through Section 18 a closed procedure in Cayman, and would potentially undermine the role of the Cayman Parliament in our submission, particularly in the context of proceedings under Section 26 of the Bill of Rights, which is obviously a key fundamental, a key constitutional provision, which was in particular the product of lengthy negotiation between the United Kingdom and Cayman, and what then?
I'm sorry, if you're moving on, what do you say about Section 26? This was one of the factors which Justice of Appeal Moses considered influential in coming to his conclusion.
I'm just about to come to Section 26 more
I
fundamentally.
thought you were moving on, sorry.
Sorry, no, all I was referring to Section 26 at this stage was just in passing because of the fact that there's a reference to Section 18 of the Grand Court Act and the importation effectively of English procedure, if I can put it that way in very simple terms. I want to come to Section 26 because I've got to address the options effectively, because that is obviously something that was at the heart of the judgment of the Court of Appeal, and in particular part of that was Section 26, and what Section 26 says, and obviously Section 26 is of importance, and I recognise I can say anything about it. The starting point is obviously the Court of Appeal's conclusion that the options available if there was no CMP were, to use its language, unattractive. We submit that in considering that, one has to be cautious for the reasons really that I've already identified, relying on the judgments of Lord Kerr and Lord Dyson. What we submit should happen, which is a trial on the material that is available to the court following the PII process, in our submission is a conventional common law approach, whereas a CMP, as Lord Kerr indicated, is a departure from that, and as Lord Dyson indicated, is a departure from that. If that potentially, and this obviously was the concerning part of the Court of Appeal, results in the applicant or the appellant succeeding in circumstances where he might not otherwise have succeeded because the respondent is less able to defend their case, that in our submission is not terribly surprising. It is the result of the proper application of PII, and PII can make it difficult, albeit generally in the criminal context, it can make it difficult for a party to defend their case. And as I've already indicated, the solution to that is, if that is regarded as unacceptable in Cayman, is for the Cayman Parliament to legislate. If that approach isn't adopted, of trying the matter as best as possible, in our submission there is obvious unfairness to the applicant. Effectively, he will bear the entire burden of the public interest in maintaining confidentiality in circumstances where, as I said, there is a potential answer if that is thought appropriate by the Cayman Parliament. In our submission, there are 4 reasons why the traditional approach to PII should be adopted. First, as I've already indicated, it is the normal approach. It is the approach that's consistent with the common law. It is a trial on the basis of material that everyone has access to and everyone can make submissions in relation to. Secondly, Section 26 in our submission supports our argument. And Section 26 is important because it gives, in our submission, the applicant, or the appellant rather, 2 rights. Firstly, the right to a determination, and secondly, the right to have that determination, the right to have a fair determination. And the alternatives in our submission proposed by the respondent are either unfair or not a determination. They either amount to assuming that the respondent has justification for their actions, or they prevent, in the case of a stay, a challenge to the decision of the respondent. Now, in passing, we would submit that Section 26 is not the equivalent of Section 7 of the Bill of Rights, which is effectively Article 6. It is not the equivalent for 2 reasons. Firstly, if it were the equivalent, one asks, why is Section 26 there? And in our submission, the reason it is there is because there is an express right to a determination. And that is in contrast to the position under Article 6. We're all aware that Carnduff in the United Kingdom held that there was nothing wrong in the circumstances of Carnduff with the matter being stayed. And the reason that conclusion was reached, and it's electronic page 1524, I might actually take you to this on the basis that unfortunately it's an admissibility judgment and so doesn't have paragraph numbers, but it's 1524. On C's, I just want to take to the question the European Court asked itself, which is at the top of paragraph 1524, the first paragraph. And the question the court asked itself was essentially whether or not, slightly paraphrasing, but in my submission fairly paraphrasing, the denial of right of access to the court was proportionate. And you will be aware, I'm sure, that Strasbourg generally, in relation to Article 6, recognises that states can deny a right of access to the court, providing they do it in a proportionate way. So, Carnduff in our submission works in an Article 6 context, Section 7 context, because it's based on the ability of states to restrict access to the court. The difference between that and Section 26 is because there is a right to determination, an express right to determination, in our submission you cannot effectively determine that something is untriable, because that is not determining the matter. And that's what Section 26 in particular brings. And in our submission, that is not surprising for two reasons based on Strasbourg authority. And they're based on Strasbourg authority because, of course, Section 26 applies effectively when human rights are an issue. And the first is, it's the authority we provided yesterday, and I apologise for it being late. It's paragraph 180 of that, Scordino. The test the European Court of Human Rights applies when it looks at whether someone
Sorry,
is...
paragraph 180
80
of Scordino.
of Scordino, is whether the state has acknowledged a violation of the convention and provided redress. Now, had Carnduff been a human rights claim, and it wasn't a human rights claim, but had it been a human rights claim, the problem with staying the proceedings is that it would potentially have left Mr. Carnduff without any acknowledgement of being a victim and without any redress. And that would have meant he would have been able to go to Strasbourg in our submission. And consistent with that, the authority we initially cited, which is still in the authorities, which is at page 3565, and it's paragraph 36, Class in Germany, an early Strasbourg authority, which made the point...
Paragraph, sorry, 36?
36, yeah. Which made the point that it's unacceptable for someone to be denied, essentially, human rights on the basis that they have a lack of knowledge of their violation. And so you can't, in our submission, stay proceeding in those circumstances, and that's why Section 26 requires a determination. And in my submission, the alternatives put forward by the respondent do not amount effectively to a determination, or if they do amount to a determination, it's not a fair determination. And that's why Section 26 also, we submit, is different to Section 7 of Article 6. Third reason why, in our submission, we submit correct approaches to proceed on the basis of the material and determine essentially whether the claim succeeds, potentially finding in favour of the applicant, is because obviously what's an issue here primarily is something analogous to Article 8, or something that is analogous to Article 8, and that requires proportionality. And proportionality is expressly a concept incorporated into the Cayman Bill of Rights by Section 19. And that means the burden must be on the respondent to justify their decision, and the respondent's options in our submission effectively avoid it having to justify, or avoid them having to justify the decision. And fourthly, in the particular context of prisoners, there is, and prisoners being located a long distance from their family, there is an express right to a fair procedure, which is a demanding right. And again, given time, I'm not going to take you to it, but it's page 1598 of the Electronic Authorities, Polyakova, paragraphs 108 and 109, which ultimately reaches the conclusion that because the impact of this sort of decision may be very long-lasting, and the indications are in this case it's going to be very long-lasting, the scrutiny has to be searching, is the language of the Strasbourg Court.
It occurs to me section 19 of the Bill of Rights may be relevant to the questions that my Lord Lloyd Jones was putting to you earlier. It's on page 914, and the first paragraph tells us, the first subsection, I suppose, tells us that all decisions and acts of public officials must be lawful, rational, proportionate, and procedurally fair, which is really, well, so it's obviously summarising for us the relevant principles of administrative law. And then 2, every person whose interests have been adversely affected by such a decision or act has a right to request and be given written reasons for that decision or act.
Yes.
Well, Mr. Southey, can you help me on this? If we were to decide that there's no special procedure available,
Yes.
why shouldn't the matter simply be remitted to the Grand Court to be decided on the basis of what has been disclosed, subject to PI?
Well, that's what we are arguing for in many respects. That's our.
That's what I understood you to say earlier.
Yes.
But I understood you in your written case to be putting forward a rather different proposition.
Well, my Lord, in our written case, I'm not sure which passage you're referring to. We recognised, firstly, that the court might feel that it was able to deal with the issue. So, having decided what approach should be taken. So, perhaps out of an excess of caution, we identified how the court could approach the issue of proportionality because we felt we needed to deal with that, just in case the court wished to proceed with it.
I wasn't addressing the question as to whether this court should deal with it or whether it should be remitted to the Grand Court.
Yes.
But I was rather concerned with the submission I understood you to make, that it would not be possible to resolve the issues, and therefore the claim should be allowed.
Well, my Lord, if I drafted it in that way, what I think we were seeking to say, I need to look again at the language we used, but what we were seeking to say was that our understanding would be that on the material available, if you just decide it on the basis of the material without making any assumptions, essentially, which is obviously one of the options my learned friend argues for, assumptions as to what the underlying material would be, we would win effectively because the material would justify the Secretary of State's decision, not the Secretary of State, the Respondent's decision. That's what we're saying. It's not that we win because this is unfair, effectively. It's we win because the burden is on the respondent to justify proportionality, and they've not met it.
If it's addressed on the merits on that basis, you say you win.
We win.
It's not your case that because there's no procedure available, it would be unfair to do anything other than to allow your claim.
No,
Right.
no. I think if it comes across in that way, that's poor drafting by me, to be frank.
Well, I'm grateful to you for clarifying it now.
Yes, it is that all we're seeking to say is we recognise that we would argue that on the material available, the respondent isn't able to justify the decision, so we win on that basis. But that is, I think, not the same as saying effectively we get some sort of
Default
win, and the outcome may be the same, but it's a different route in terms of logic, and that's certainly what we meant to say.
Thank you. It's very helpful.
Can I deal then? So that's what we say in terms of procedure. I'm conscious of time. Can I deal very briefly with Begum? Because obviously Begum, I've dealt with Kanda. I haven't dealt with Begum. Begum, in our submission can be distinguished, as is clear from the judgment, because Begum was not concerned with human rights issues. It was, and the judgment is quite clear to distinguish between human rights issues and the issues that were before the Supreme Court in Begum. And paragraph 69 in particular makes it clear.
Page?
Sorry, it's electronic 1273 probably, so I've got it as 1272, but that's because I put in my own note 64 as my starting point, so 60, 1274 I'm told, very helpfully.
Yes.
And it makes it very clear that although an appeal in general is a review, the appellate body is required to determine directly whether there's been compatibility with the European Convention on Human Rights. Not suggesting in any way that the court, the tribunal in that context, could avoid determining the human rights issues. I mean, I can take you through the archaeology of the case, or the sort of detail of the case to try and demonstrate
It's
why.
an extraordinarily complex archaeology.
Yes, it is. So that's why I'm sort of slightly conscious because of the time not wanting to do that.
Yes.
But it's quite clear when one works it through that it was, I mean, the closest it came to the convention was there was a Home Office policy of applying effectively convention standards outside the application of the convention. But there was no direct convention issue in play.
Yeah. But the problem there was that if one gave effect to the Secretary of State's concerns about national security, then Ms. Begum couldn't be admitted to the UK, and that, we were told, was going to adversely affect her ability to participate meaningfully in the proceedings, and therefore affect her prospects of achieving a just resolution of the proceedings.
Yeah.
But because the possibility existed that the difficulty might be overcome, I mean, we didn't go into the various ways in which it might be, but there were possible ways in which it might be overcome. The just solution in the circumstances was to stay the proceedings, to await the possible situation where she could play a meaningful role in the proceedings.
Absolutely. But I think from my point of view, the point I just need to make, at the risk of repeating myself, is that we would submit it very clear that it is not authority for the proposition that you can avoid effectively determining a human rights claim. Far from it. It is said expressly that there is a need to determine that, and that's consistent with Strasbourg authority. In this jurisdiction, it's consistent with the obligation in Section 26. Turning to the two alternatives, I'm going to deal with these very quickly. Firstly, in terms of effectively rejecting the claim, applying the principle of legality, the principle of legality, as far as I think we're concerned, as far as we're aware of, it was last considered at presumption of regularity. Sorry. Yes. Sorry. Yes. Or presumption of legality. Sorry. It's jet lag probably kicking in at that point. But it was last considered, obviously, at the UK Supreme Court level in the Paralambus case. In simple terms, in our submission, as the Court of Appeal in this case found, it's quite clear that the ultimate conclusion reached is at paragraph 52, which is page 1361 again, I think, which is that, actually maybe 1362, sorry, I think again I've got an earlier reference in my notes to an earlier paragraph.
Yes.
Was that Westminster, in a human rights context and in a judicial review text, is unattractive and capable of denying judicial review of real teeth. And obviously, in the context of Section 26, it's very difficult to see how it's compatible with Section 26 to apply the Westminster principle. The alternative in our submission, which is put forward, well, actually, before saying that, there are sort of two sub-alternatives. That one relying on the Westminster line, but the alternative essentially that is put forward is that there is sufficient reasoning to demonstrate that the decision is justified. In one sense, if the matter is remitted back to the Grand Court, that's probably an issue for the Grand Court as to whether or not the material is sufficient to justify. All we would say, which is why we would submit we're entitled to more material and why PII potentially applies, is that the material that's currently being put forward is inadequate, effectively, to justify the decisions. What my learned friend effectively invites with this sort of option the court to do is essentially say, well, you should assume that there is material that justifies the conclusions that's being reached. And we would submit that is inconsistent with Section 26 and the Strasbourg Authority requiring searching review of the decision. The other alternative is stay, and I've dealt with Calm, Duff and Bagan. All I ought to just mention in passing is AHK. AHK is, as far as we're aware, the only case where it's been concluded, essentially, that a matter that relies in part on human rights should be held to be untriable. It's a first instance decision. It never went on appeal. Well, it did go on appeal, but it was never determined on appeal because the Justice and Security Act came in subsequently. And we don't accept that in a context where Section 26 applies and entitles someone to a determination, AHK can be applied, because it quite simply was not a determination of human rights issues. It was a conclusion that they were on trial. That leaves me a short period of time to move on to the last two issues. I think I've dealt now with what we say about whether there's power to hold a closed procedure. I think I've dealt with what we say about the options. And to be clear, our case on that, given any lack of clarity on my part, our case on that is the court should effectively try the material on the material that is before it, following the PII process. It would be open to us, essentially, to argue that material is insufficient to justify the decision of the challenge, but that ultimately will be a question for the court. And we will be able to argue, essentially, about whether or not there is sufficient material to justify conclusions reached, for example. The last two issues we submit are linked, partly because the issue about the consideration of children demonstrates, in one sense, the issue that the primary issue, which is whether or not the interference, essentially, with Article 8 rights, Section 9 rights, was in accordance with the law. Very quickly, we do submit that the starting point in relation to this is that the interference with the rights was obviously very significant. The evidence before the Court of Appeal, and the Court of Appeal, obviously, to be fair, and we don't challenge this, it reached the conclusion in paragraph 38, electronic page 23, that the impact was significant. But the evidence was, in particular, that while detained in Cayman, the applicant was able to have visits from his son every weekend. His affidavit, which was unsworn because of the COVID pandemic, is at page 347 of the electronic bundle, and the relevant references in particular are paragraphs 4, 5 and 16. The child's mother's evidence, electronic bundle, page 358, paragraph 18, was that removal had been very hard on her son. Her third affidavit, page 404, paragraph 4, was that her son had no memory. And the reality is that there have been no visits by her son by the son rather, to the father since the father has been detained in the United Kingdom. There have been now 2 sets of visits. When we drafted it, was still the case that there had only been 1. There has been a second visit. The first visit, the son didn't participate because the mother couldn't travel because she was pregnant. On instructions, I'm told that the second visit didn't involve the son because the mother, in this case, on the second visit, was unable to travel. This time, she was unable to get time off work, and also was responsible for childcare for a new child, basically. So there has been no visits by son to father since he's been imprisoned in the United Kingdom. All of that, in our submission, demonstrates the significance of the interference, and it is unsurprising, given the likelihood of those sorts of considerations, that if you look at the European Court of Human Rights fact sheet, page 3904, the European Court of Human Rights helpfully has produced a series of fact sheets. I'm sure the court's seen those fact sheets that sort of try to bring together the various conclusions of the court in relation to particular topics. And it has one on effectively location of prisoners and the impact of that. And if one looks at that, the 4 cases where it's identified on the fact sheet that the distances are in the thousands of miles, and obviously in lots of Europe there aren't going to be moves of thousands of miles, but it tends to be Russia because obviously that's the country with largest distances. You see
Are we on 3904?
3904.
Yes, I thought so, thank you.
Yeah, sorry. If you look at the 4 long distance removals, and I was going to take all of those are held to be in violation of Article 8, which demonstrate not obviously that you can't do it. I just for your note, I want to. The cases are Kordakovsky, Wittmann, Polyakova, and Voynov. All of those cases where you're talking about long distances, really long distances, not locations on the other side of Italy, for example, there are found to be violations. Now, I'm not suggesting that means it's an inevitable win in this case. That obviously would be wrong as a matter of principle. But it does demonstrate the sensitivity of this sort of decision, because it has massive impacts on families.
We don't have any information about how, I mean, for example, prisoners for high security, persons convicted who are thought to require high security are treated in, say, French Polynesia or the Dutch Antilles.
As far as I'm aware, that issue hasn't come before Strasbourg.
No. There'd be a better, if you like, it's a closer parallel,
it is a closer parallel
than Russian prisoners being taken to Siberia.
Yeah. Yes, although the concern of the European Court was clearly just the sheer logistics of visits taking place, and that's why the analogy you can refer to this in one sense. And remember, and I'll come back to this. Strasbourg has talked about how a lack of resources is no answer in this context. It's a very demanding standard that Strasbourg sets in this context.
But presumably they haven't said that in the context of, the one high security prisoner in French Polynesia.
But they haven't said that. What we did have below, and I don't want to mislead the court, and so maybe over lunch I'll just double check the material, is we did have material that indicated this is very rare in the British Overseas Territories, and apart from Cayman, where it's an issue, and there have been 4, I think, if I now remember the number correctly. I think it happened once in Turks and Caicos, was it? I think it was one other jurisdiction once, and there isn't, for example, apparently an issue with some of the other jurisdictions, like, for example, Bermuda, which are similar-sized populations. So it is not clear necessarily on the evidence that other British overseas territories don't cope with this, because it for some reason, it's happened 4 times in Cayman. It doesn't seem to be something that happens commonly in other overseas territories. But Can we try and get the reference to that, because there was confirmation of that over lunch. It may or may not be in the edited record of proceedings, and I can't remember whether that material is there. All I was going to say was that what Polyakova demonstrates is that one of the reasons why this is so important, I won't take you to it, but it's worth reading in my submission, 1592, is that rehabilitation is now, in Strasbourg's language, a key objective, essentially, of the penal system, and rehabilitation, in Strasbourg's view, is clearly facilitated by enabling people to maintain contacts with the outside world. And if you put someone many miles away, you interfere with that. Now, I'm not going to take you to, but because of the passage of time, the absence really of any contemporaneous documentation considering the position of the children. The Court of Appeal accepted paragraph 11 that the contemporaneous documentation regarding the decision-making was poor. That's paragraph 11. It accepted that the submissions made to the Secretary of State to justify the decision made no reference to the children, paragraph 153. And the Governor's affidavit, which is referred to, and again the Court of Appeal referred to this, indicated that advice had been given that they needed to consider the right of the family. Strikingly, that affidavit says nothing about how that advice was followed up. All one has, essentially, is letters written after the event dealing with the position of the children.
This is something I'm still puzzled as to what relevance these essentially merits points have to the outcome of this appeal. As I understand it, the Court of Appeal's judgment is that the case, the judicial review, should be remitted to the Grand Court, but with a CMP process. Your appeal seeks an order that the matter be remitted to the Grand Court without a CMP process. At the moment, I can't see how that decision for the board is affected by what one might, and I don't mean them pejoratively in any sense, regard as merits questions of this kind.
Well, the difficulty, the reason is the Court of Appeal concluded there was a public law challenge essentially as to whether or not account had been taken of public law stroke Article 8 challenge as to whether or not account had been taken of the position of the children. And that aspect was dismissed on the basis that the court concluded there was adequate consideration of that. Now, we say, so that is...
You want to be unbound by
we want to be unbound by
that point.
But it's also, the other reason why we draw attention to that is that what we ultimately say in terms of in accordance with the law is that I can deal with this fairly quickly, but it's relevant, and this is why I said the last two issues are linked, is that we don't dispute that the basic principle that has to be considered when deciding whether or not something is in accordance with the law is the judgment is essentially as identified by my Lord Reid and then endorsed by Lord Sumption in P, which is does the legislation essentially allow the proportionality of the measure to be assessed? That has to be applied in context, not least because obviously it's pretty trite that one can't ever have certainty, one can't have there has to be sometimes a degree of uncertainty about how legislation works, and etc. But in this particular context, in our submission, it goes back to Polyakova, which we submit is the key authority. What in our submission is clear from Polyakova is that the law needs to ensure that matters that counterbalance whatever the authority's justification for moving someone are adequately identified, and also the impact on the individual has to be a factor that needs to be considered. And that's a particular problem in this case, in our submission, because one of the factors that we identify in our written case, and we identified below, is that at the time the decision was taken, there are no rights effectively other than those generally given to foreign national prisoners, that identify, for example, what arrangements will be made to facilitate visits in the United Kingdom. If you look at the letter from the Attorney General, the letter says, essentially, we may be able to facilitate some visits. So when the decision was taken and when the move took place, the law didn't provide, for example, that there was any right for family members to have funded visits. It didn't say how often those visits should take place. It treated, the best that can be pointed to is the fact that the applicant, the appellant, would have the rights essentially of a foreign national prisoner. But he's not in the position of a foreign national prisoner. Foreign national prisoner has, because they've been convicted of a crime in the United Kingdom, decided to commit a crime in the United Kingdom. They run the risk then of being imprisoned and punished in the United Kingdom. This is someone who was convicted in Cayman. The normal way in which they serve their sentence is in Cayman for good reason, because that facilitates them. And what their rights are in terms of family visits is completely, to some extent, left at the discretion of the state. And that's, in our submission, one of the difficulties. We also make the point that there is nothing that says, for example, in legislation, in secondary legislation, in policy, you need to take account of matters such as family life. And that's the other reason why family life is relevant, because on the face of it, you have this gap in the legislation that says, yes, these are circumstances where you may be able to move someone, but you also need to take account of their family life, etc. And we then have a decision-making process which, on the face of it, perhaps is consistent with that, where family life, counterbalancing factors, to use the language of Polikova, simply aren't weighed in the balance. And when I talk about the importance of family visits and funding those, can I just give you the reference to Polikova, the relevant passages? We refer to paragraphs 92, 99, 100. But then 113 is where the court talks about there being a need to use its language, respect dignity regardless of financial difficulties. And the reference to dignity links back to the fact that the European Court, when it first talked about why Article 8 is engaged in this context, referred to dignity as being the basis upon which effectively rehabilitation is so central. And so the European Court, in the context of Article 8, linked these rights back to dignity. Yes. Sorry, Respondent very helpfully has identified the material. I don't think it's in the bundle. What that material indicates is that there have been, the letter says there were 3 criminal transfers from the Cayman Islands to the United Kingdom in the last 10 years. That doesn't take account of Mr. Richards, who was the first transferee, because he was more than 10 years ago. He's the 2009. That's why we refer to this issue being identified in 2009. So overall, there have been 4 transfers. There have been 2 transfers from other overseas territories to the Cayman Islands. There have been 0 transfers from Cayman to other overseas territories. There were 0 transfers from Cayman to Jamaica. And there were 0 transfers from the following overseas territories: Anguilla, Bermuda, BVI, Falklands, Montserrat, Pitcairn, Henderson, Duce and Emo Islands, and St. Helena. The other overseas territories there was no evidence for, save for Turks and Caicos, and I was right, there was 1 transfer from Turks and Caicos. I'm told it's page 616 of the bundle. So, to some extent, that's an indication that certainly some jurisdictions seem to be able to cope with this issue. How they do it, we have no more information, but that's the extent of the information we have. I think given we started late, I'm slightly ahead of time. Can I just turn to my... Thank you.
I don't think you're ahead of time.
Well, my lord, I think we started a little late, so I had 2 hours. So I'm referring to clawing back some time, my lord, but maybe that's not a subject we can argue about.
Well, I mean, if you have matters you need to add,
No,
then obviously we'll hear you.
oh, no, my lord, I'm satisfied. I was just trying to claim credit where perhaps credit wasn't due.
Oh, I see. I see. Well, yes, I think you do perhaps get 5 minutes credit.
Yes.
Well, thank you, Mr. Southey. I think, Mr. Bowen, before we call on you, we'll adjourn for a few minutes to decide on which matters we need to hear you on.
So can I just raise one thing?
Yes,
Those
sorry.
friends have drawn attention to it, and I'm quite happy to clarify this. I mentioned what we understood to be the reasons for the child's mother not travelling. I understand that those reasons are in dispute, and really, to be frank, that's not really the point I was trying to make. It was obviously that for whatever reason, the child has been unable to visit his father, rather, in circumstances where obviously he had been able to in Cayman. So I just wanted to clarify that.
Yes. Thank you, Mr. Southey. And Mr. Bowen, we were, I think, brought back onto the bench a little prematurely, so don't worry that you weren't here when we first came.
Yes, I'm terribly sorry.
No, I'm saying there's no need to apologise. We were brought back a little early. Now, we've considered the issues in which we need to hear you, and by reference to the statement of fact and issues, we'd like to hear you on issue 1, which is the CMP issue, and issue 2, which is where do we go next in these proceedings?
Well, my Lord, can I start in this way? What I'm proposing to do, I had been planning to take you from the first issue to the second issue, but what I'm going to do is, having wrapped up our submissions in summary, I'm going to take you to the second issue first, because the second issue really is the reason why the first issue needs to be decided in the way that we say it does. So I'll be developing the submission that if there is no CMP, this matter simply cannot be decided in the appellant's favour if it were to be returned to the Crown Court. My Lords, just by way of introduction of the facts, and I'm not going to labour this point, but the appellant and his half-brother are considered to be extremely dangerous individuals. They've been convicted of a murder which, as the Court of Appeal described it, had all the hallmarks of a gangland killing. They were imprisoned in a Category B prison here at HMP Northwood, in circumstances where they are considered to be too dangerous. They are designated as Category A prisoners in the United Kingdom. In June 2017, the Governor was made aware of intelligence that had come into the possession of the police and the prison service. And that included information from informants that the appellants were continuing their activities of smuggling automatic weapons, and hitmen from Jamaica